Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesslink. I'll be arraigning you this afternoon. That involves me reading the charges to you, then telling you what your rights are, and then addressing bond. I have with me on Zoom Mr. Brown as a defense attorney and Mr. Fortier from the prosecutor's office. The charge in the complaint against you reads as follows. It says, in honor about July the 10th of 2025 in Bagley Township of Otsego County, that you did commit the following two offenses. Count one is entitled breaking and entering a vehicle to steal property between $200 and $1,000. It says that you did enter or break into a Chevy Equinox, a motor vehicle, to steal or unlawfully remove property therefrom of a value of $200 or more, but less than $1,000, contrary to Michigan compiled law. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 fine, or 3 times the value of the property stolen, whichever is greater. Do you understand the name of count one?
It's a misdemeanor count, correct?
That's correct. Do you understand the name of it to be breaking and entering a vehicle to steal property between $200 and $1,000?
Okay.
I just need to know if you understand that, sir. Not asking if you agree with it.
Yes, I understand.
All right, and you understand the misdemeanor maximum penalty is 1 year and or $2,000 and up to 3 times the value of the property, whichever is greater?
Yep.
All right, count two reads as follows. It says that on the same date, time, and place that you did commit the offense of breaking and entering a vehicle to steal property less than $200, and that says that you did enter or break into a Ford F-150, a motor vehicle, to steal property or unlawfully remove property therefrom of a value less than $200. That also is a misdemeanor offense, but it has a maximum penalty of 93 days and or $500, or 3 times the value of the property stolen, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum penalty for count two?
Yes.
All right. Right now, you have certain rights as to those charges, and I want to make sure that you understand them so that you can make an informed decision in the future. You have the right to plead guilty, not guilty, or no contest. You have the right to an attorney to represent you, and you have the right to have a trial by a judge or by a jury. Mr. Brown is here to assist us with the attorney, and we'll talk about that in just a minute. If you wish to have a trial in the future, you also have the following trial rights: to see, hear, and question all the witnesses against you, to present witnesses and evidence for your defense, and to get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Finally, you'd also have the right to appeal automatically any error that happened at trial. However, if you enter a plea in the future, you may be limited to asking the court for permission to appeal. Do you understand all of those trial rights?
Yes.
Do you have any questions about any of those trial rights?
No.
All right. Mr. Brown, have you had a chance to speak to Mr. Winter about his right to an attorney?
Yes, Your Honor. He would qualify, and that information has been sent to Mr. Keel's office.
Thank you. Mr. Winter, are you asking for court-appointed counsel?
Yes.
All right. I will approve that request. That request has been submitted to that approval will be submitted to Mr. Gilo, who's the supervisor of the court-appointed attorneys. He will decide which specific attorney will be assigned to you for your case. In the meantime, I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with that lawyer. I'm also going to set a pretrial conference quickly so that your lawyer can speak with the prosecutor and see if they can resolve the case quickly as well. Do you have any questions about those procedures, sir?
No, I just need to be able to talk to my attorney because there is extenuating circumstances.
Well, we'll get into that later. You don't want to talk about anything right now, Mr. Winter.
Yep, and that's why I've set a quick pretrial conference.
Buckle up, guys. Today we're going to dive into one of the most bizarre court appearances you'll ever see. It kicks off with a defendant who thinks is smarter than the system, and from the jump, it's clear we're in for a ride. The host set the tone with a quick sponsor plug, but once the defendant's name is called, the real story begins. If you think this is just another misdemeanor arraignment, think again. This guy brings chaos to the courtroom like it's a talent.
And then the attorney will contact you subsequently. All right, now that we've set those things, I will address bond. So what I'm going to do is I'm going to hear from each of the attorneys as to bond, and then, sir, I'm going to listen to what you have to say, if anything, about bond as well. So, Mr. Fortier, your thoughts.
Your Honor, I did submit a bond recommendation form. In there, I did request a $5,000 cash or surety bond. That's largely, I mean, it's a larger amount considering what he's charged with in the fact that they're both misdemeanors. However, I'm requesting that amount partially based on the fact that these were two thefts within motor vehicles that were part of a string of essentially vehicle burglaries. And on top of that, his criminal history is quite extensive. It is listed in that recommendation form. He's out on parole for a home invasion second degree. So he's got a history of stealing other people's property. That wasn't even his first home invasion. He had another one back in 2008. So like I said, he's on parole for that. He does have a parole hold. I confirmed that with Agent Doug DeLeo with the Department of Corrections. So there is an administrative warrant that's holding him. So regardless of what the court sets the bond amount at, he's not going anywhere, essentially. So in addition to the amount requested, we are seeking that there be the standard conditions of bond, along with no drugs or alcohol, no illicit controlled substances, and then to not have any contact with Timony Bonifant or Mallory Bonifant. They are the two vehicle owners that are in this case, and then also not to return to the property of 19 Grove Avenue here in Gaylord. That's the property where the theft occurred.
All right, Mr. Brown.
Thank you, Your Honor. Mr. Winter is a lifelong resident of this county. He has ties to this community. I don't think he's going to go anywhere. Failure to appear is not really going to be an issue. It is my understanding he did, or possibly was arraigned yesterday on an FOC warrant. So I don't know if there's a significant bond in that matter as well. But as Mr. Fortier mentioned, he is on a parole hold, so bond is really not a huge issue, as he's not going to be able to bond out no matter what it is set at. But I would ask the court just to consider the charges. These are misdemeanor charges. Also, he did mention to me that he does have some mental health issues that he is taking medication for. I don't know what the jail's policy is or if he's getting those medications, but that is something that he requested, that he be provided any kind of medications that he needs. And then, again, I don't know who even has those medications. Thank you.
Those medications are here at the jail now, Your Honor.
Thank you for letting me know that. I appreciate it. Mr. Winter, you also have the right to speak to me about bond. However, I simply want to caution you not to make any statements about the underlying facts of this case, because we are recording this proceeding and I don't want it to be used against you in the future. Is there anything else, however, that you want me to be aware of in setting a bond?
No, Your Honor, I have to speak to my attorney about that.
All right, guys, now it starts getting real. The judge formally reads the charges, and the defendant, Jonathan Winner, is facing not one, but two breaking and entering misdemeanors. But what makes this gripping is how calmly it's laid out, even though the charges suggest a pattern. The judge is methodical, explaining everything in plain terms, while the tension builds. This isn't just legal procedure, it's a calm before a very loud storm.
Wishes in the future he can readdress that issue, and I'll consider it at that point. I would confirm, because Mr. Brown brought it up, there was a friend of the court hearing, I believe either yesterday or the day before, My memory is that there was a bond set in the amount of $4,900 that he could be released upon payment of that. I do not know whether that has occurred yet or not. So I
No,
would
I have
assume.
not been able to do that, Your Honor. I'm not going to be able to do that.
All right. I appreciate that, Mr. Winter. Thank you. All right. In setting a bond, I am required to look at whether or not the person will appear as required, and then if there's any danger to the community. The prosecutor brings up history, and which is quite extensive, including resisting and obstructing convictions twice in 2004, larceny in a building in 2004, home invasion in third in 2008. Prisoner in possession of weapons in 2013, and then a second home invasion, this time a home invasion second in 2019. Also, what the prosecutor alleges is a string of vehicle burglaries, of which this may have been a part. So for those reasons, I would need to believe that Mr. Winter might be a danger to the community. However, these are simply misdemeanor matters, and I do believe that $5,000 cash assured is a little high on that end, given the fact that he has a parole hold and also an FOC warrant with extensive, a relatively large dollar amount on it. It's unlikely he's going to be able to post bond, so therefore I'm not going to set the bond in this matter quite so high. I will set it at, because of his prior histories, I'm not going to give him a 10% bond, so I will set it simply at $500 cash or surety.
Here's where the red flags start waving. The judge asks if Winter needs an attorney, and he not only says yes, he immediately starts hinting at extenuating circumstances. That's courtroom code for something strange coming soon. His tone shifts. Something's off, and you can feel it. The judge knows it too, advising silence before this turns into a self-destruction session. This part is short, but it's a first real crack in the defendant's composure.
Court, the call matters of State of Michigan versus Alex Dopfer.
Your Honor, I believe that's Mr. Winter.
Is that Mr. Winter? All right. So change things here. All right, this is the State of Michigan versus Jonathan Winter, file 25-43924-FY. Can I have your name for the record, sir?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesselink. I'm coming to you from the district court. You're here today for an arraignment, so I'm going to tell you what you're charged with, tell you what your rights are, and then we'll discuss bond. The complaint that's been made against you reads as follows. It says that on or about July the 7th of 2025 in the city of Gaylord, Otsego County, that you did commit the following two offenses. Count one is named breaking and entering a building with intent. It reads that you did break and enter a storage shed located at 619 West Mitchell Street with the intent to commit the crime of larceny therein, contrary to the Michigan compiled laws. That is a felony offense. It has a maximum penalty of 10 years. You understand the name of that offense?
No.
What don't you understand about it?
What's the date of that offense?
The name of that offense.
Oh, I'm sorry, Your Honor. Yes, I understand.
All right. Do you understand the maximum penalty of that offense?
Yeah.
All right. Count two alleges stolen property, receiving and concealing over $200 but less than $1,000. It reads as follows. It says that on that same date, time, and place, July 7th of 2025 in the city of Gaylord, Otsego County, that you did commit the offense of receiving and concealing stolen property over $200 but less than $1,000 by buying, receiving, possessing, concealing, or aiding in the concealing of an e-bike, stolen, embezzled, or converted property, knowing that it was, or having reason to know that it was the property was stolen, embezzled, or converted, and the value was between $200 and $1,000. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 or 3 times the value of the property, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum possible penalty of count two?
Yes.
This is where the courtroom drops the hammer. The prosecutor lays out Winter's history, and it's brutal. We're talking home invasions, parole violations, multiple thefts, all wrapped in a pattern of repeat behavior. What should be a simple bond hearing turns into a complete expose. This isn't just about 2 cars, it's about a criminal career. You can almost hear the judge recalibrating the case as a true weight of Winner's past is brought into the light.
For tier count 2, I believe, is charged as a second or subsequent offense. Is that correct?
It is, Your Honor.
And then once that's done, that moves it from a misdemeanor up to a felony, and then both count 1 and count 2 would be subject to the habitual offender 4th offense notice. Is that correct?
Correct, Your Honor. Both counts would be subject to that notice.
All right. So listen carefully, Mr. Winner. Count 2 right now was originally charged as a misdemeanor, but it also alleges that you have a prior, or at least one prior conviction, so that you would be a second or subsequent offender. And because of that, the penalty is increased to a felony level. So I want to make sure that you understand that. So count 2 starts out as a misdemeanor. It's alleged to be a second or subsequent offense by saying that appearing that on June 14th of 2012, you were previously convicted of attempting to commit, receiving and concealing stolen property, 200 or more, but less than $1,000 in the 87A District Court. And therefore, this is alleged to be a second or subsequent offense. And because it is a second or subsequent offense, it is now a felony offense, which has a maximum penalty of 5 years and or a $10,000 fine or 3 times the value of the property, whichever is greater. Do you understand now that count 2 has been raised to a felony level offense?
Yes.
All right. Now, as to both count 1, which is a 10-year felony, and count 2, which is now has a subsequent offense notice, which raises it to a 5-year felony, there is also a habitual offender notice, habitual offender 4th offense notice, which also has the impact of raising the penalty. So I want you to listen carefully to this as well. It says that you are previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about July 29th of 2019, you were convicted of the offense of home invasion 2nd degree in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. On or about April 4th of 2017, you were convicted of the offense of prisoner possessing contraband in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about May 7th of 2013, you were convicted of the offense of prisoner possessing weapons in violation of the Michigan compiled laws in the 46th Circuit Court for the County of Otsego in the state of Michigan. Now, because these two, count 1 and count 2, both have a penalty of 5 years or more, the 4th habitual offender notice makes each of those a potential life felony offense. You understand the new maximum penalty on both count 1 and count 2 is now life imprisonment?
Unfortunately.
Just when things heat up, we hit a twist. The defense attorney steps in and drops a bombshell. Winner is on medication for mental health issues. Suddenly, the conversation shifts from crime to competency. Is this guy making poor decisions? Or is he mentally unstable? The judge takes it seriously, confirming the jail has his meds, but the doubt has been planted. What was just a long rap sheet now becomes a laid character study.
Are and what the maximum penalty is. Right now you have certain rights as to each of those charges, and I want to make sure that you understand each of those rights. You have the right to plead guilty, not guilty, or no contest. You have the right to be represented by an attorney in any of these proceedings going forward, and you have the right to have a trial by a judge or by a jury. If you, we're going to address your attorney in just a minute, but if you wanted to have a trial, you'd have the following trial rights. You'd have the right to see, hear, and question the witnesses against you. You'd have the right to present witnesses and evidence on your own behalf and get an order from the court called a subpoena requiring those witnesses to appear and testify. You could testify or you could remain silent, and if you chose to remain silent, that silence could not be used against you. You would also have at trial the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal any error. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights that I've just given you?
Yes.
You have any questions about any of those rights?
That's why I talked to my attorney, Your Honor.
All right, that's a good idea. Mr. Brown, have you had an opportunity to discuss counsel with Mr. Winter?
I have, Your Honor. He will qualify. That information has been sent to Mr. Gilo's office. I currently represent him on another case. It is more than likely I'm going to be appointed to this one as well.
All right. So, Mr. Winter, what I'm going to do is I'm going to appoint court-appointed counsel for you, or approve court-appointed counsel for you. That information is going to be sent to the administrator who deals with court-appointed attorneys, who will appoint a specific attorney for you. That may be Mr. Brown, because you already have a relationship with him. But in the meantime, until you have a chance to speak with that lawyer, I'm going to enter a not guilty plea on your behalf in order to preserve your rights. I'm also going to set a couple of quick court hearings to help preserve your rights. The first will be set within 7 days. That's called a probable cause conference. That's a chance for the prosecutor and the defense attorney to discuss the case and see if there's a way to resolve it quickly. I'm also going to set a preliminary examination within the next 21 days. That's a hearing in district court before me as the judge, to find out if there's a small amount of evidence called probable cause to believe that you've committed the crimes that you've been charged with. It is not a determination of guilt or innocence. It simply is a check to make sure that there's sufficient evidence to proceed. Do you have any questions about those two hearings that we just talked about?
No, Your Honor, but I really need to have my attorney come here and talk to me way before any court date I have, because I have to talk to him about things that he needs to do for me that are very important and they are absolutely relevant to these cases.
Here's a rare moment of self-awareness. The judge offers Winner the floor to speak, but this time he chooses silence. He actually says he wants to speak to his lawyer first, a smart move. For once, he hits pause on the rambling and holds back. But the damage is already done. Between his record and his mental health flag, the narrative is shaping up fast. It's like watching someone try to fix a leak after the flood's already taken the house.
All right, Mr. Winter, I will notify the attorney that he needs to talk to you. However, I can't make any guarantees as to what his schedule is, so I'm sure that he will do his best. If you need additional time, you can make that known at the next court date that you need additional time. All right. We're now going to address bond, and I'm going to ask each of the lawyers what their thoughts are on bond, and then I'm also going to give you an opportunity to tell me what you want me to know about bond as well. Mr. Fortier, your thoughts as to bond.
Your Honor, Mr. Winter has a terrible criminal history. He has 6 or 7 prior felony convictions, several misdemeanors. He does have a administrative warrant that's been placed on him by Agent Doug DeLeo with the Department of Corrections. So he's not going anywhere on the parole violation. So I would just ask the court to just set a bond amount, knowing that he's not going to go anywhere. And then in the event that somehow he is able to bond out, just having the standard conditions of bond put in place, and that there be no consumption of any alcohol or illicit controlled substances, no bars, random testing, to report via community corrections, and that he not have contact with the victim in the case, which is, his name is Jason Vanderlaan, and not to return to the address listed in count 1.
All right. Mr. Brown?
Your Honor, everything Mr. Fortier says is correct. I was with him when he was arraigned, I think last week, on a misdemeanor. Court issued a $500 cash or surety bond, and he was in the exact same position. As far as his parole detainer, he hasn't posted that bond either. So whatever the bond amount is, he is very, very unlikely to be taken off that detainer in time to post it. So I would ask court to consider that when setting a bond in this particular matter as well.
All right, thank you. Mr. Winter, I simply want to caution you before you make any statements that anything that you say right now is being recorded, so it could be used against you later. So I don't want you to make any statements about the facts of this underlying case. But if you have information for me that would relate to bond, I'd be happy to listen to that. And this is your opportunity, sir.
Your Honor, I have no further information than what they have already told you in the courtroom right now.
This is a part where the bond decision comes in, but the irony is thick. The judge sets a lower bond, but it doesn't matter. Winner isn't going anywhere thanks to a $5,000 hold from a separate case, likely child support. It's a moment of dark humor in a case that's spiraling. On paper, he gets a break. In reality, it's just another locked door in a life full of them. And the real trouble? It's only just getting started.
All right, the two things that I am required to do in general on bond determination is to protect the public and also to ensure the defendant's appearance in the future. Part of that is a review of the defendant's criminal history to see how that may impact those two things. I would note that in 2004, in 46th Circuit Court, Mr. Winter was convicted of attempted resisting and obstructing police officers. 2004, he was also convicted of, again, attempting to resist police officers. 2004, he was also convicted of larceny in a building. 2005, it's like a non-sufficient funds check. Number of misdemeanors in 2007, 2008, 2009, he was convicted of home invasion, 3rd degree. 2011, a misdemeanor for drugs. 2012, misdemeanor stolen or receiving and concealing stolen property between 200 and 1,000. 2013, or marijuana drug offense misdemeanors. 2013 in 46th Circuit Court, drug felony, second offense notice. 2013 46th Circuit Court, prisoner in possession of weapons. 2017 jail contraband in 46th Circuit Court. 2019 home invasion, 2nd degree. And then we have a bunch of files, I believe, if memory serves, pending within district court now against Mr. Winter. Based on the serious nature of the charges with the habitual 4th offender notice and his criminal history, I'm going to set bond at $5,000 cash or surety, no 10%. His actions with the police and his dangerousness, as shown by his criminal history, don't warrant a 10% bond. If he is able to post bond, he must personally appear for any scheduled court date. He must abide by any judgment of the court, may not leave the state of Michigan without permission of the court, may not commit any crime while released, must immediately notify the court in writing of any change of address or telephone number, may not use alcohol or illegal controlled substances while on bond, must participate in a substance abuse testing or monitoring program through community corrections, may not possess or purchase a firearm or other dangerous weapon. May not have any contact, direct or indirect, with Jason Vanderlaan. Direct or indirect means by third parties, by computer, by internet, social media, or any other way. You may not have any contact whatsoever with Jason Vanderlaan. You also may not enter the following premises or area: 619 West Mitchell Street in Gaylord, Michigan. And you must contact, upon your release from jail, within 24 hours, the Community Corrections, which is the agency that monitors the persons that are on felony bail for the court. And that phone number will be provided to you upon your release by the jail. You have any questions as to the bond in this case, Mr. Winter?
And now the case explodes. Winter is back before the judge, but this time it's not for misdemeanors, it's for a felony. His hit with breaking and entering a storage shed and concealing stolen property. The stakes skyrocket. 10 years maximum. His confusion over the charges adds to the drama. It's clear now, this wasn't a one-off. This is a man buried under a lifetime of bad choices, and the court is finally catching up. Like the video, subscribe to the channel, and we'll see you in the next video.
Files on Jonathan Winter. versus State of Michigan versus Jonathan Wenner, file 25-43901-SM, set for a status conference. And then we also have State of Michigan versus Jonathan Wenner, file 25-43924-FY, set for a status review. Is that you, Mr. Wenner, in the jail?
Yes, it is, Your Honor.
All right, thank you, sir. Looks like we have Mr. Brown covering on this case, on both of these cases as well. Mr. Brown, do we have a resolution of either matter?
We do not, Your Honor. I know that Mr. Wenner has been wanting me to go to jail to visit him. I did that yesterday. The conversation did not go very well. I don't believe we had much accomplished. He wants, as far as both these cases, I believe, to have a criminal responsibility examination set, and he would like to request a new attorney.
And a full psychological evaluation, Your Honor.
You can certainly pay for a full psychological evaluation, but I don't believe that there's any law that requires the court to pay for that on your behalf. There are two.
It has to be approved. It has to be approved by the court in order for community mental health to help me set that up.
As far as criminal matters go, I don't know why the court would order a full psychological evaluation. I don't know exactly what you're looking for. There are two standard orders that the court enters in criminal cases. One is called competency, and that looks at whether or not you are able to understand the criminal justice process and able to assist your attorney in representing you during that process. That's, do you understand the nature of the charges and the court proceedings? And do you understand enough to be able to assist your attorney through that process? The other court order that could be done is called criminal responsibility. And that's a determination of whether or not you were legally insane at the time that the crime was, that the crime occurred. A psychological evaluation is typically used in family court matters to determine what types of assistance that you may need with mental health in proceeding through another court hearing in a family court or in civil court, or in making some assessments about what type of programs or services that you may need. And those are typically not available in a criminal court. So what is it specifically that you are asking for of the court?
I'm requesting a criminal responsibility test and a full psychological evaluation that community mental health told me on Tuesday this week that you guys can order and approve, but it has to be approved through you. Yes, there's a 6-month waiting list, and I do not care about staying in here that long. I need a full psychological evaluation done, and community mental health told me that you can approve that to get that done.
Well, then I'm going to need to have something from community mental health that tells me why I need to do that and under what circumstances they're looking for it and what they would use it for. So without something in writing asking for that, I can't know what specifically you're asking for and why I need to order it. Those things are expensive, and if I don't know why I need to have it or why you need to have it, I don't know. I'm not going to just do it out of due course.
Your Honor, these things are absolutely necessary and relevant to my defense because I'm having psychological issues without my medication during the times of these crimes.
I still need something in writing, and that's done in every criminal case. I need something in writing from your attorney and or from community mental health as to understand what the purpose is being used for. I understand that you believe that it's relevant, but I need something in writing from a person.
But it's absolutely relevant to my case.
I understand that you think that, but I don't know that for sure yet. So I need something from community mental health that tells me why, and it needs to be in writing so that the prosecutor and the court can decide on that. And I need more than 30 seconds notice to be able to reach that decision. So I'm going to need something.
I have my attorney come see me before this court date to let you know these things. And I also told Mr. Brown yesterday that I would like the paperwork or to request the paperwork or whatever I need to do to get a new court-appointed attorney because he is not representing me to the way that I need him to.
Just because you disagree with what your attorney tells you doesn't mean that you have the right to have a new attorney.
Your Honor, he's
you
telling me
don't
that
have-
he won't do things, he won't talk to witnesses, he won't do none of this crap unless he feels that it is necessary. That's not the way this works.
Unfortunately, it is.
No,
Your
it's not,
attorney is-
Your Honor, I'm sorry.
You don't get to tell your attorney what it is that you want to do all the time if it's not appropriate. He's there to help you understand what is and is not appropriate. There are things that you
Your Honor,
do.
I've not said nothing to him, I've not said nothing to him that's
Mr. Wenner.
inappropriate, Your Honor. He's
Mr.
refusing
Wenner,
to do things for me.
this is not going to work if you're going to talk over me.
I need a new court-appointed attorney, Your Honor, I'm sorry. Larry Brown is fired.
Unfortunately, you don't have the ability to fire him. You've asked for a court-appointed attorney. The court has appointed him. You can ask.
I'm requesting a new court-appointed attorney because of him not doing his job the way he should by representing me properly.
All right, Mr. Wenner, here's how this is going to work then.
I also have past
Listen,
experience, Mr. Brown,
listen.
by not representing me properly.
Shut him off for a minute.
He's muted.
Thank you. Mr. Wenner, this will not work if you're simply going to talk at me. I need you to understand what I'm going to say next, and then I'll unmute you, and you'll be able to tell me what it is that you want me to know. But this will not work if you're simply going to come into court and try to dictate what is going to happen. Your rights are going to be preserved, but you do not run how the court works. If you want to ask for another court-appointed attorney, I will grant that request. But if the next attorney comes in and does things that you do not like, I will not appoint another attorney for you. You do not get to fire anybody when you ask the court to pay the burden of that attorney. And you're going to be stuck with whatever. Please unmute Mr. Wenner.
So I don't have the right to unmute him, but I have requested it. If there is an officer in there.
Just for the record,
There we
Your
go.
Honor, there is a form that he must fill out. If he fills that out, gets that back to me, I will get it to the proper authority for determining whether he's entitled to a new attorney.
Thank you, Mr. Brown. So, Mr. Wenner, you're going to have to fill out a form to ask for another court-appointed attorney, and I'll approve that once it's gotten to me, and then you'll have another attorney. Do you have any other questions for the court today, sir?
Besides adjourning or postponing or whatever the preliminary hearing in order to do this, no. Or whatever you gotta do for postponing the hearing or whatever you got. Besides that, no.
Your Honor, I guess I misunderstood. Is he wanting the prelim within 21 days, not willing to waive it?
No, I think he's asking to postpone it so that he can get a new attorney. Is that correct, Mr. Wenner?
Yes, but also at that time, I would go through the attorney on whether to, waive the 21-day rule or not.
Well, I don't know how long it's going to take to get this new attorney for you.
And
The arraignment.
yes, Your Honor, I'd like, I'm sorry, Your Honor, go ahead.
Thank you. The arraignment on file 43901, which is the misdemeanor case, was in July. The arraignment on the felony matter, which is file 43924, was in the beginning of August. So I think we've got some time, and we should be able to get a court-appointed attorney changed in that time period before he has to waive. Let me see if there's any other court dates set yet.
His prelim is set for next Thursday on the felony case.
All right. Mr. Wenner, right now, the preliminary examination is set for August 21st, which is a week from now. And I doubt very seriously if the attorney is going to get changed and up to speed within that time frame. So do you want to go through that process and bump the preliminary examination back? That is to waive your 21 days to allow that process to occur?
Yes, I would like to waive that 21 days, yes.
Is that you, Mr. Wenner? I'm not able to hear Mr. Winter from the jail. If we could have him unmuted.
Believe they're working on it.
All right. In the interim, I'm going to just call that case. This is the State of Michigan versus Jonathan Winter. There are a number of files. Let me put all of them on the record. First is file 25-43947-FY, set for a status review. Next is file 25-43928-FY, also set for a status review. We have file 25-43901 set for a status conference. That's a misdemeanor. And we have file 25-43924-FY set for a status review on the felony. So we have 4 Winter cases. Mr. Winter, are you able to hear me now?
Can you hear me, Your Honor?
I can. Thank you very much. All right. Last time we were in court, you asked for another court-appointed attorney, and I indicated that I would grant that request and see if one would be scheduled. Since that time, I've learned that the court-appointed attorney's office has denied that request, and you're stuck with Mr. Brown, apparently. Mr. Brown, have you had any additional information?
I did, Your Honor. I did receive that denial. I have attempted to speak with Mr. Winter again. Basically, we are having the same situation. He will not really speak to me other than telling me what I need to do. I'm not really sure where to go from here. At the last court hearing, he wanted a psychological evaluation done. The court explained that to him. I've explained to him, you know, I could request some sort of a forensic interview, but that's generally done for pleas of insanity, which I don't think he really understands what all is entailed, because the communication really broke down there, and he would not really listen to me explain the different plea options he has. Again, he is essentially trying to tell me how to run the case based upon things that he wants. And while it is, obviously, I am going to do my absolute best to represent my client, I have certain ethical and legal. I have certain ethical and legal obligations, and there are certain things that I cannot do or I won't do, because that could get him into trouble and me into trouble, Your Honor.
Mr. Brown, I appreciate that. Mr. Winter, I am going to give you an opportunity to say something in just a minute, but first I want to make sure that you have the appropriate information. I have received a written request from, I assume that this is you, Mr. Winter, and I'm trying to make sure I can read it. Says that you are the defendant in the above referenced case, and you request a new court-appointed attorney for the following reasons. Then you wrote in the box, it appears to say misrepresentation due to refusal to order tests I need done, and refusal to take statements or to call as witnesses to prove history of mental health issues getting worse, not acting as my lawyer, but as a prosecutor towards me and I can't read that final word. Then it says Larry Brown Jr. To be replaced. And then I've also received a document entitled with the case name on it from the MIDC contract administrator, Mr. Slough, which addresses your request for substitution of court-appointed counsel and the MIDC counsel administrator determination, in which he denies your request. Have you received a copy of that document?
I have it in my hand right now, Your Honor.
I'm sorry. Yes, you do?
Yes, I have it in my hand right now.
Okay, I just didn't understand what you said. So that's the status of that request. Is there anything that you want to add to that at this time?
Really, Your Honor, the conversation that I had with Mr. Brown on the phone yesterday, obviously he said did not go very well because it didn't. Because pretty much in the middle of it, he pretty much told me that he's not going to represent me properly because he just thinks I'm a criminal. I'm nothing but a criminal. That's not what a defense attorney is supposed to say to his client, Your Honor. I'm sorry.
Whether he said it or not really doesn't make a whole lot of difference. The question is, does he represent you well in
because that
court?
means he's discriminating against me and only prejudice against me
Mr.
because of my past offenses. Yes,
Mr.
I've
Winter?
been dumb. I got a lot of offenses. I was stupid, and I made a lot of mistakes. But that does not justify the kind of person that I am. It does not tell me the kind of person that I am or the kind of problems or issues I was having during these times.
All right. Thank you. I want to make sure that you've completed your statement there before I say anything else. Are you done, Mr. Winter?
Besides requesting that I get a responsibility test done or whatever, I need evaluations done, Your Honor. I'm sorry. Mr. Brown told me that it would take a while for that to happen. I'd be sitting in here for a long time waiting for it, and I don't care how long I gotta wait for it. I don't. I gotta have these done, and I gotta be able to prove and have people, because the only people that I can have talk to and prove my past mental issues are my family and my family doctor.
Okay.
Your Honor, just,
And I get told all the time that my family is not good enough to provide this
All right,
information or my doctor.
Mr. Winter, you have to wait. You're going to get time to say what you want to say, but you can't keep talking over. As soon as somebody else starts, you can't start again. So when you take a breath,
That's why I kept going.
are you done now?
For a minute, yeah.
The misdemeanor case was in July. The arraignment on the felony matter, which is file 43924, was in the beginning of August. So I think we've got some time, and we should be able to get a court-appointed attorney change in that time period before he has to waive. Let me see if there's any other court dates set yet.
His prelim is set for next Thursday on the felony case.
All right. Mr. Winter, right now, the preliminary examination is set for August 21st, which is a week from now. And I doubt very seriously if the attorney is going to get changed and up to speed within that time frame. So do you want to go through that process and bump the preliminary examination back? That is to waive your 21 days to allow that process to occur?
Yes, I would like to waive that 21 days, yes.
Is that you, Mr. Winter? I'm not able to hear Mr. Winter from the jail. If we could have him unmuted.
Believe they're working on it.
All right. In the interim, I'm going to just call that case. This is the State of Michigan versus Jonathan Winter. There are a number of files. Let me put all of them on the record. First is file 25-43947-FY, set for a status review. Next is file 25-43928-FY, also set for a status review. We have file 25-43901 set for a status conference. That's a misdemeanor. We have file 25-43924-FY set for a status review on the felony. So we have 4 Winter cases. Mr. Winter, are you able to hear me now?
Can you hear me, Your Honor?
I can. Thank you very much. All right. Last time we were in court, you asked for another court-appointed attorney, and I indicated that I would grant that request and see if one would be scheduled. Since that time, I've learned that the court-appointed attorney's office has denied that request, and you're stuck with Mr. Brown, apparently. Mr. Brown, have you had any additional information?
I did, Your Honor. I did receive that denial. I have attempted to speak with Mr. Winter again. Basically, we are having the same situation. He will not really speak to me other than telling me what I need to do. I'm not really sure where to go from here. At the last court hearing, he wanted a psychological evaluation done. The court explained that to him. I've explained to him, I could request some sort of a forensic interview, but that's generally done for pleas of insanity, which I don't think he really understands what all is entailed, because the communication really broke down there, and he would not really listen to me explain the different plea options he has. again, he is essentially trying to tell me how to run the case based upon things that he wants. And while it is, obviously, I am going to do my absolute best to represent my client, I have certain
Your Honor,
ethical
I'm
and
say about that
legal,
right quick.
I have certain ethical and legal obligations, and there are certain things that I cannot do or I won't do because that could get him into.
Appreciate that. Mr. Winter, I am going to give you an opportunity to say something in just a minute, but first I want to make sure that you have the appropriate information. I have received a written request from, I assume that this is you, Mr. Winter, and I'm trying to make sure I can read it. Says that you are the defendant in the above referenced case and you request a new court-appointed attorney for the following reasons. Then you wrote in the box, it appears to say misrepresentation due to refusal to order tests I need done and refusal to take statements or to call as witnesses to prove history of mental health issues getting worse, not acting as my lawyer, but as a prosecutor towards me in, and I can't read that final word. Then it says Larry Brown Jr. To be replaced. And then I've also received a document entitled with the case name on it from the MIDC contract administrator, Mr. Slough, which addresses your request for substitution of court-appointed counsel and the MIDC counsel administrator determination in which he denies your request. Have you received a copy of that document?
I have it in my hand right now, Your Honor.
I'm sorry, yes, you do?
Yes, I have it in my hands right now.
Okay, I just didn't understand what you said. So that's the status of that request. Is there anything that you want to add to that at this time?
Really, Your Honor, the conversation that I had with Mr. Brown on the phone yesterday, obviously he said did not go very well because it didn't. Because pretty much in the middle of it, he pretty much told me that he's not going to represent me properly because he just thinks I'm a criminal. I'm nothing but a criminal. That's not what a defense attorney is supposed to say to his client, Your Honor. I'm sorry.
Whether he said it or not really doesn't make a whole lot of difference. The question is, does he represent you well in
because
court?
that means he's discriminating against me and holding prejudice against me because of my past offenses. Yes,
Mr.
I'm
Winter?
dumb. I got a lot of offenses. I was stupid, and I made a lot of mistakes. But that does not justify the kind of person that I am. It does not tell me the kind of person that I am or the kind of problems or issues I was having during these times.
All right. Thank you. I want to make sure that you've completed your statement there before I say anything else. Are you done, Mr. Winter?
Besides requesting that I get a responsibility test done or whatever, I need evaluations done, Your Honor. I'm sorry. Mr. Brown told me that it would take a while for that to happen. I've been sitting in here for a long time waiting for it, and I don't care how long I gotta wait for it. I don't. I gotta have these done, and I gotta be able to prove and have people, because the only people that I can have talk to and prove my past mental issues are my family.